When it comes to aerial pesticide application, liability and safety, they are top of mind. A recent court ruling involving the crash of a crop duster provides some key insight as to how risk should be allocated in ag aviation contracts. The man to help us decipher all of this, Roger McEowen with the Washburn School of Law. Roger, always a pleasure. We're going to start with a little background on this case. Give us some details here.
Well, good to be with you, Suzanne. This was an experienced crop duster that flew his helicopter over land that was owned by a landowner that was leased out to a tenant and was hired by an agribusiness, an ag company, and a consultant. So you've got a whole bunch of people here that hired him to apply pesticide to a field. He does this, but there's a low-hanging steel dove wire. Now, this is a decoy wire that hunters will use to attract doves. So it's not a power pole. You hang a decoy. It kind of looks like it, and they come in and they set on that wire, and you use that for dove hunting purposes. And that spanned the field, and he got his helicopter caught up in that. And despite a prior reporting of a near miss, neither the landowner nor the consultant warned the pilot. And so while he's out dusting that field, the helicopter struck the wire and crashed, and he died. And so his estate sued the farm owner, sued the agribusiness, sued the consultant, as well as the tenant for negligence.
And how did the courts rule on this?
Well, interestingly enough, this was in North Carolina, and the trial court granted summary judgment for all the defendants. Said you don't owe him any duty at all. It's his fault, and he was contributorily negligent, and he didn't let the jury hear the case. Now, it went on to appeals, and this is the U.S. Court of Appeals for the Fourth Circuit. The appellate court said that's wrong. The issue of foreseeability and whether there's a duty, those are jury issues. The jury has to determine that. And the same thing the court said applied for the contributory negligence issue. You've got to let a jury determine this case.
What are the implications from the courts in this ruling?
Well, I think there are several of them. And the court, if they're going to send these cases to juries, which frankly is probably the right thing to do, make sure as a landowner or as an agribusiness or a consultant, make sure you do a hazard survey, either by visual inspection or by drones. We can use drones for these types of things now. Do a flyover, just get an inspection, and prepare a written hazard disclosure and probably a site map, and provide it to the pilot showing all potential obstructions, wires and poles and fences and towers, and mark or flag all of your low-level flight hazards and make sure all the parties are insured. There's more, but those are the basics.
That's a great idea to fly that drone overhead. I mean, we're using drones more and more on these operations. Overall, producers, keeping in mind when allocating risk in aviation contracts, what do they need to do?
Well, Suzanne, I think the key point is that liability for ag aviation accidents involving hidden obstacles can be shared and cannot be contractually or procedurally offloaded without clear written terms and by taking some proactive measures. So if you take the time to explicitly allocate duties and liabilities related to hazard identification and warning, the parties can reduce any ambiguity and litigation exposure. And I think that's the lesson coming out of this case.
Yeah, such a sad situation for sure, all the way around, sure. And of course for that pilot. Roger, as always, a pleasure. Roger McEowen with the Washburn School of Law. And you can find more about that case, by the way, on his website, also on ours.